Hey guys, how are you all? My name is Harshit Devedi friends and I welcome you back to my video. So in this video friends, I will be talking to you regarding the Central Administrative Tribunal. This is given in according to the provisions of Article 323A of the Indian Constitution. With this, I will talk to you regarding this Part 14A of the Indian Constitution, and there is one more article, Article 323B of the Indian Constitution. So all of these things deal with one thing, that is tribunal, the role of tribunals in our Indian Constitution friends. So this is presented by me, Harshit Devedi. If you want to follow me friends, the link of my Instagram profile is given in the description box below. Also, this video is in English friends. If you want to watch the Hindi version of the video, the link is given below. Moving forward. Now see, originally the tribunals were not there in our Indian Constitution. So they were added to the Indian Constitution through adding this Part 14A to the Constitution of India by the 42nd Constitution Amendment Act of 1976. So this 42nd Constitution Amendment Act of 1976 was enacted in the aftermath of emergency during the Prime Ministership of Indira Gandhi. And this was a sort of mini constitution because it had many dictatorial tendencies. Obviously, when Janta government came in 1977, this they brought the 44th Amendment Act 1978, which nullified major provisions of this 42nd Amendment. So, this 42nd Amendment added Part 14A, which is still existent, which contains provisions with respect to what? The tribunals in India. Now, there are two articles in this Part 14A. One is Article 323B, 323A. So 323A contains administrative tribunal. 323B contains tribunals dealing with other matters. Now, first we are going to talk about these administrative tribunals. So Article 323A gives the power to the parliament so that administrative tribunals could be established. And what will be the work of this administrative tribunal? That public services of the center friends, also services of the states, local bodies, public corporation, public authorities. So all the staff which is working in these public services, or you can say working in the government department, state government department, so they will be having their own problems, service condition related problems, recruitment related problems. So all of these cases will go to Central Administrative Tribunal in accordance with the provisions of Article 323A, and also to the state administrative tribunals. So Central Administrative Tribunal is formed in order to look after the issues related to recruitment and conditions of services of the persons in government departments, or I should say public services. Okay friends, so this is one thing. So all the things, service conditions, administrative problems, recruitment related to government jobs, public services, comes under the jurisdiction of this Central Administrative Tribunal. So what this Article 323A of the Indian Constitution did, previously all of these cases would go to civil courts and high courts. But now these cases were taken out of the jurisdiction of civil courts and high courts, and they were put under the jurisdiction of the administrative tribunals. Now what it did friends, the point is that this was being made to provide speedy and inexpensive justice through the aggrieved public servants. See, civil courts and high courts were already burdened with a lot of other cases. Now if these type of cases were also going to civil court and high court, then the justice dispensation process would have been very late to these aggrieved public servants. So by forming a special administrative tribunal for them, justice dispensation to them can be given a bit faster. Okay, so obviously in pursuance of this Article 323A, Parliament passed this Administrative Tribunal Act in 1985 friends, and this act authorized the central government to set one central administrative tribunal at the center, and in states Central Administrative Tribunal. Obviously in state there will be one state administrative tribunal. Okay, moving forward friends, so these things are there. Now friends, it was being set up in 1985 under the act. Its principal judge bench was at Delhi friends. There were benches in other states also. There were a total of 17 benches. 15 were 15 of them were operating at the bench of the High Court only, and two separately, that is Jaipur and Lucknow. So that is not very important friends, because this changes from time to time. Okay, now original jurisdiction with respect to recruitment and service matter comes under the jurisdiction of CAT. Okay, CAT also have jurisdiction over all India services, civil services of the center, that is Group A, Group B, Group C, Group D, employees of the central government, central civil services, and civil employees of defense services. So in the defense services there are many civilian employees also. For example, when you will give the exam of SSC friends, there is a post of assistants in Air Force headquarters. So obviously that is a civilian employee, that is not a defense employee. So he will be covered under the provisions of Central Administrative Tribunal. Now, what does not comes under the jurisdiction of Central Administrative Tribunal? So in that case, the secretarial staff of the parliament, then the defense, civilian employees of the defense forces. Okay, friends. The members of the defense, not the civilians. The civilian employees of the defense forces will be coming in the Central Administrative Tribunal. So obviously, the members of Army, Navy, and Air Force who are involved in court processes, that is members of the defense forces, they will also not come under Central Administrative Tribunal. And the people working in the Supreme Court, they will also not come under the jurisdiction of Central Administrative Tribunal. So the Central Administrative Tribunal is a multi-member body. It has a chairman and other members. Originally, it used to have a chairman, vice chairman, and other members. But one amendment was done to the Central Administrative Tribunal Act 1985 and 2006. And through this amendment, all the members of the Central Administrative Tribunal were given the status of the judge of a high court. Now, this was a big privilege, friends. Getting status equivalent to the judge of the High Court is a big privilege. And since 2016, the strength of the sanctioned strength of the Central Administrative Tribunal, chairman is 1, and the members are 65, and they will be appointed by the president, friends. Okay, and they will belong to both judicial stream and also the administrative stream. So even if it is a tribunal, all the members are not from the judiciary. There are some members from administration also, because when we talk about public services, it has a lot of administrative elements also. So wider amount of representation has been given. Okay, friends. Now, if you talk about the tenure of the chairman and member, so the tenure of both the chairman and member in Central Administrative Tribunal is 5 years. Okay. Now, age limit is different. In case of chairman, the upper age limit is 65 years. In case of member, it is 62 years. So this is also one more important thing, friends. Now, when the appointment of the members is made, some issues comes, friends. For example, when appointment of the members of Central Administrative Tribunal is made, they are made on the basis of the recommendations of a selection committee. Now, this selection committee is headed by a sitting judge of the Supreme Court, and this sitting judge of the Supreme Court is nominated on the recommendations of the Chief Justice of India. So, whatever selections, your nominations or recommendations this selection committee is going to give, the Chief Justice of India will give the concurrence to that name, and then that name will go to the Cabinet Committee on Appointments. And as soon as the Cabinet Committee on Appointments gives its approval, that person becomes the member of the Central Administrative Tribunal. Now, if we talk about the way of operation of Central Administrative Tribunal, so Central Administrative Tribunal is not bound, and it is not important for Central Administrative Tribunal to work in a manner which is given in the Civil Procedure Code. This means, friends, that Central Administrative Tribunal is guided by the principles of natural justice. So whatever it is going to do, it will follow the principles of natural justice, that is, the aggrieved public servant, all sorts of good things can happen to him, all sorts of, he should get justice. So this is the thing. Also, CAT is flexible in its approach. It can slightly alter its approach also if it feels that is important. And applying in CAT for a case is very, very easy. Only 50 rupees fees is charged. Also, the applicant who is applying in CAT, either he can represent himself through a lawyer, or he can himself also represent himself in the Central Administrative Tribunal. Now, there has been some changes, friends. See, what happened initially till 1997, whatever orders the Central Administrative Tribunal used to give, the appeal against those orders cannot go to the High Court. They have to go to the Supreme Court, friends. So this was there, but what happened? Supreme Court in Chandra Kumar case of 1997 said that judicial review is a part of basic structure of the Constitution, and High Court has the power to judicial review. So obviously, all the orders which are given by Central Administrative Tribunal, the first appeal to them will lie to the High Court. It will lie to the division bench of the concerned High Court. And after that concerned High Court gives his decision, then if the public servant wants, he can go to the Supreme Court. So now he cannot directly go to the Supreme Court. That is, if CAT has given an order, previously what public servants used to do, they used to directly go to the Supreme Court. Now they have to go to the division bench of the concerned High Court, and when that High Court gives the decision, then they can go to the Supreme Court. Okay, friends. So this was about Central Administrative Tribunal. Now let us talk about State Administrative Tribunals, friends. They are also established under the provisions of this Administrative Tribunals Act of this 1985. Okay, central administrative tribunals are actually established by central government on the specific request of the state government. So for example, Uttar Pradesh state government wants a state administrative tribunal, so it was request to the central government, and then central government will appoint the state administrative tribunals. Around 12-13 states have set up administrative tribunals in them, friends. And also, what is the jurisdiction of state administrative tribunal? It will have original jurisdiction with respect to service related matters and recruitment matters of state government employees. Okay, now when we talk about the members and chairmen of this SAT, State Administrative Tribunal, so the members and chairmen will be appointed by whom? By the president on the recommendations and with consultation with the governor of the state concerned. And there is also a provision that joint administrative tribunal can be set up, friends, and this joint administrative tribunal will be there for two or more than two states, and in this case also the chairman and members will be appointed by the president in consultation with the governors with all the concerned states of all the concerned states. So this was about tribunals mentioned under Article 323A. Now we are going to discuss about tribunals mentioned under Article 323B. So in Article 323B, under it, Parliament and state legislature both are authorized to establish tribunal, friends. Okay, and they can establish tribunals with respect to taxation, foreign exchange, import and export, industrial labor, land reform, ceiling on urban property, election to Parliament and state legislature, food stuff, and rent and tenancy rights. Okay, now see, friends, what is the difference between Article 323A and Article 323B? See, the very first thing you need to know that tribunals under Article 323A can be established only by the Parliament. But tribunals under Article 323B can be established by both the Parliament and state legislatures, and obviously state legislatures can establish tribunals on those particular matters which come under the state list, on which they have legislative competence, and state governments have legislative competence on state list and concurrent list. So with respect to those matters, they can set up the tribunals. So this is one difference, friends. But when we talk about our second difference is Article 323A. In this, there will be one tribunal for the center. When we will talk about state, there will be one tribunal for the state. And if we talk about joint administrative tribunal, there will be tribunals for two or more states. But there will be no hierarchy of tribunal, friends. But what will happen under Article 323B? Both the Parliament and state legislature can set up tribunals in their own legislative competence. So a sort of hierarchy of tribunals can be created by both the Parliament and state legislatures. But such hierarchy is not existing in the case of Article 323A, friends. So this is one more important thing. Okay. Also, friends, the tribunal which is established under Article 323A, it deals only with public service matter, friends. Okay, public service, recruitment, service conditions. So these are the things on which the tribunals of Article 323A will be dealing. But when we talk about Article 323B, they can deal with matters, other matters. For example, the matters I talked about, land reforms, ceiling on urban property, industrial labor, elections to Parliament, state legislature, food stuff, rent and tenancy rights. So these are the matters on which tribunals under Article 323B can also be made. Under Article 323A, tribunals with respect to government job, public services will only be made. So these were the information, all complete information about this tribunal, friends. I hope this thing becomes clear to you. This is very, very easy. If you thought that I was a bit fast, you can again rewind the video and watch it. So I hope this video was liked by you, friends. Kindly subscribe to my channel, like this video and share and comment and tell me how you like this video. You can also ask your doubts through the comment section below. Please share these videos more and more to your friends. Goodbye, friends. Have a great day. Goodbye. Take care.